And I do see that. I see a interim GAL report, review of temporary orders today, and then also to set a final written GAL report date today. So where are we at, Ms. Corey?
So I have had the opportunity to speak with both parents as well as meet with Jaden twice. And this is a very angry young man. I believe that and I am concerned that he's feeling like he's really in the middle of this conflict between his parents. And I also believe that and am concerned that he may be hearing people in both households speak poorly of the other parent. And I did want to remind them about that. I think it's imperative that Jaden get counseling immediately. The last time I met with him, he told me that he had gone once, but his mom said he didn't have to go back again. So I think that needs a little oomph behind it. And I'm going to withhold, I think, for right now, any other recommendation beyond the counseling. But perhaps dialing back the visitation schedule at this point might be a good idea. So to maybe one full weekend a month, one full weekend day, rather than, I believe we're at first, third, and fifth weekends, but just dialing it back a bit, kind of give Jaden some breathing space. And I know I'm kind of dumping this on the attorneys right now, and I apologize.
I'm ready when Your Honor is ready for argument.
Sure, go ahead, Ms. Baldwin.
So the court this case has been pending for a long time. It was filed in 2020 when my client was incarcerated. He was released in the summer of 2021, did everything to get his ducks in a row, filed a motion to resume visits because they were not willingly resumed in the fall, late fall of 2021. Again, after getting a job, getting things in line, so he could sort of prove to the court that this was not some flash in the pan. He's been doing, from there were multiple hearings where we had to force mom to do reunification counseling, where the court had to say, you have to actually set an appointment, finally get reunification going late, or not late, but into the spring of 2022. We do reunification counseling essentially for a year. We're coming to the end of 2022. During that period of time, Ms. Rosen was working with the family. Visits were expanding under essentially her authorization and her understanding that she could expand visits. Visits, by all accounts, were going extremely well. Mother then got a new attorney, was told, hey, you don't have to expand visits. So they went from a planned overnight snowboarding trip to, hey, here's your 2 hours supervised. From there, visits started taking. And so then we go from doing really well in December of 2022 to being ratcheted back into these 2 hour supervised visits with Ms. Rosen. And then if the court will recall, then child was refusing to go entirely, to where the court then had to most recently say, you have to send the child. It's not acceptable to not allow the child to just decline. And most recently, we had child running directly from mother's car to McDonald's, where he called 911 and essentially was expecting 911 to intervene and not require the visit. This reeks of alienation. It just does. Mothers never wanted to reunify the child. Child's now been told you don't have to go to counseling. You don't have to do the things the court's ordered you to do. Hey, let's go run into a business and call 911 to frustrate the visit. The child's in the middle because the mother's putting him there. My client wants a relationship with this child. At this point, we have spent 2 years getting to a point of having normalized visitation. The idea that we reward mother by ratcheting back and reward her behavior doesn't make any sense. The only way a child is going to get to a place of peace is if the court is clear that you can't do this to the child. These are the visits. This is what we're doing. We are moving forward. This idea that we're going to kind of just allow the cycle to continue is not appropriate for the child, and certainly not in this young man's best interests. Again, real concerns in this case. The court recently made orders regarding relocation. Again, in this case, I don't envy the guardian ad litem in this case. I think she has a very difficult job. But my request is the visits stay the same. Mother is required to call and get the child into counseling today, full stop. The idea that she can just say, you don't have to go, you don't have to do this anymore. Again, it's rewarding. We're creating a system where we're rewarding that behavior, both in child and in mother. That's not appropriate. So I think that we continue the visits, allow the guardian ad litem additional time. I think in a reasonable amount of time is 3 months. I know that's a long period of time for the guardian ad litem, but because of the dynamics of the case, I think the guardian ad litem needs more time. And the reality of, even if mother's required to call today to get the child in, it doesn't mean the child's seen today. And to get records, to get any kind of relationship built and records from that counselor, that just takes time. So I would put this case back on for a final review, essentially towards the end of the year. I think that that's a reasonable course of action, but we should not reduce visits. Mother should be required to get child into counseling and provide proof to the court that that's happened. And we should also set a review to ensure that, for the sole purpose of ensuring that happens, because given the track record of this case, it won't happen absent a review.
So, question to anyone. Sorry, excuse me. Child was seeing Miss Rosen. That's when we were last here on the 13th of June, and that's stopped now?
They were using her for reunification counseling. So I guess I don't know if Ms. Corey is thinking reunification or more of a personal counselor.
I am definitely thinking of more of a personal counselor. I believe that the reunification counseling has ran its course, and that Jaden would be very resistant to going back there.
I don't disagree.
Ms. Jeffers?
Your Honor, fathers seems to keep saying because it was a rough road at the beginning that mother should be punished forever. It was a rough road at the beginning because father was incarcerated so long for violent crimes, and there was some legitimate fears. The reality is that excuse me. The reality is that mother's been doing what the court has said. The child refused to go. The court, we talked about this at length on the record about when father's there, leaving the child. That's what mother has been doing. And there's certainly no allegations that she hasn't. So there can't be any, allegations that mother's alienating. That's just not correct. She's been forcing the visits. Additionally, she went and got the child his own counselor. Last time I knew, he was still in counseling. I don't have any knowledge to the contrary. And it certainly wasn't her position that he should just stop counseling. He's had some real issues with what's been going on. There's been a lot of police involvement, nothing to do with mother. Mother's already left the child by the time that occurs. The visits themselves have been going terribly. I believe as recently as this last weekend, father sending the child messages that say, you're doing bad in school. You will be punished your whole visitation. You could expect to stay in a room and not do anything fun. And the child is acting out. It's not going well. I think that he does need to go to counseling, and we should see what the counselor has to say. Mother's supportive of the visitation. She's going to do what the court says to do. And certainly if there's anybody in her household talking bad about father, that's going to be addressed immediately. Because she wants this to go forward. She wants her kid to be okay. And the reality is he hasn't been since this visitation has started. And I believe that's the basis of the recommendation of the GAL. If we're having a child that's reacting this negatively, not just in not wanting to go, but acting out in school, acting out in destructive behaviors that he has never engaged in the past, I think that there should be let's find out what's going on and let's see how we fix this. So I would ask the court I don't have a problem with the counseling, don't have the problem. Neither parent should be talking poorly about the other in the presence of the child or allow third parties to do so. Absolutely agreed, 100%. But I do know that there's a lot of problems with the visitation. And I think it's more important that the visitations start going well than we just keep forcing the issue with more and more backlash from the child. Thank you, Your Honor.
Thank you, Ms. Jeffers. Ms. Corey, do you, anything else you want to add?
I don't think so.
Ms. Jeffers, is the 90 days for a final GAL report suggested by Ms. Baldwin, does that sound fair to you?
I think that's fine, Your Honor.
All right. And Ms. Baldwin, any final comments?
My only concern are, the visits are going poorly. You can't say that mother's in compliance when it's, I'll drop you off, but with instructions to call 911. It's not going, that's not compliance. It's just not. You're setting up the child for failure. You're setting up visits for failure. That's harm to the child. We have to get to a place where mother is not creating this negativity.
All right. Here's what I want to do. I guess I have general concerns. Clearly there's two very different versions of what's going on here. I do recall 7 months ago, 8 months ago, maybe not even that long ago, we were at a really good place with visitations. And they weren't supervised. They weren't, as far as I recall, not professionally supervised. And things were progressing well. And then mom did stop a planned trip and things were ratcheted back from there. And there was a request, I think, to move, and a whole bunch of things happened sort of over the ensuing several months after that. Why things are all of a sudden not going well, whether that's the mom intervening in a negative way or things really being that negative at dad's house. I don't know that the court can make a decision on that. What I am very concerned about is the child's well-being, because clearly something's going on. And frankly, it could be completely unrelated to any of this other than he's, caught in the middle. So I think we need to get him engaged in a personal counselor as quickly as possible. That's going to be the number one most important thing. Both parents should have access to that counselor as far as to if the counselor wants to inquire of them, not necessarily to provide information to the parents about what child's saying, but to allow the parents to express what they're observing or what their concerns may be. And I want that to happen as quickly as possible. I understand that we may be able to make an appointment soon, but that appointment may not happen soon. So are the parties available on in 2 weeks on the 29th?
I can be, Your Honor. And
So
I'm pretty sure we can get a quick counseling appointment. He's already got a counselor and has started.
Okay.
Whether that's continued, I don't know, but we'll get that going if it hasn't.
All right. So here's what I want to have happen. I am going to put a short stay on visitations. Let's focus on counseling. I'd like a report back on the 29th. So in 2 weeks, of just some insight, and with barring any extreme concerns from counselor, with the intent of getting visitation restarted. And even if that's reconfiguring what that looks like, on the 29th. But between now and the 29th, I don't know if phone or FaceTime visits or anything like that have been happening. If parties are comfortable with that. Also, no disparaging comments by parents to the child or any other adult or individuals in the parent's presence to the child about the other parent will be allowed. I will set the 90-day review. Does November 14th work for everyone?
I am currently scheduled to be in a trial the 14th and 15th, Your Honor.
All right. I think I'm out the following. So the 7th of November.
Yeah, my
That
preference
works
is the
perfectly.
7th.
All right. So Ms. Corey, does the 7th of November work for you?
It actually does not. I have 2 trials that week.
Oh,
Well, but I would ask that we just maintain the 7th. guardian items aren't generally necessary for the entire trial. And so my thought is she should be able to come over and handle this matter if that's necessary.
All right. Yeah, we'll keep November 7th, and then everybody can just keep everybody appraised of their schedules. So November 7th, 1:00 PM for final GAL report. And then update from counseling to the court, the 29th at 1:00.
Yes, Your Honor. I just want to, as far as filing with the counselor, an absolute deadline, because that's obviously 2 weeks. I'm not sure when the last appointment took place. I can try to get an immediate letter, but what's your cutoff? Because I just anticipate I'm just going to be filing from the counselor. Is that the court's anticipation as well?
I think at this point, yes.
Okay.
And if that stems other issues and responses needed, then obviously we can have a review prior to that November date.
Last day to submit that?
Ms. Baldwin, you want to weigh in on that, or?
I mean, it is what it is. The court at this point is terminating my client's visitation after 2 years of effort from him. This is incredibly discouraging for him. So for him, this is challenging. He doesn't want to delay anything. File it the hour before. We want to go forward. If we're in this position where we're terminating visits until we get a report, that motivates one side to delay. And that's kind of the inherent problems where we've terminated visits in the interim.
And I have no intention, Your Honor. I just need a cutoff date so I can move on that quickly.
Is the most up-to-date information that we can get is fine. And if that is an email to all of us the morning of the 28th with the most recent information and filed later, then that's fine with me.
Okay. Done deal.
And just so, sorry, I was looking at the wrong month.
29.
Next month is it's the 29th, sorry. So the morning of the 29th, I misspoke. And as I stated, I understand it's, I'm sure Mr. Rance feels like he's always the one bearing the brunt of the issues here. And, I'm sorry for that, but the child's well-being is, and the concerns that have been raised, that's where we're at. But this hopefully will only be a very short period of time. So we'll review the 29th at 1 PM.
So before we move on though, I do have specific requests. My client has zero information about this counselor that we are now being informed at Docket has been selected and the child is seeing. The counselor's name, address, phone number should be provided today by end of business. Similarly, mothers should sign all releases for my client to be able to communicate with that counselor again by end of business today or tomorrow. My concern here is the court's authorized my client to have access to provide information, but without my client knowing who that person is, that's impossible to do. So these are kind of the inherent concerns that my client has. And additionally, if the court's ordering visits with the counselor, those visits should be required to be consistent and regular, such that the child's actually getting therapeutic value. My concern is the child's seen the person once. We'll see them once before your order today, and then we'll see them again. And that's not my understanding of your order.
Your Honor, I think we can deal with a lot of these issues. The GAL has the counselor's information. I have no problem with her providing it. I don't know whether I'll be able to talk to my client today. But, these are kind of what the kid is going through. It's like these demands that you do this right now, you do this right now. The father's actually doing to the child. This is part of the problem. Of course, I will provide that information to opposing counsel. The counselor will be informed that father can give input if the counselor wants it. The last thing I want is the child trying to establish trust with this counselor and father putting an immense amount of pressure on the counselor. Why don't we see where the child's at and then see what orders are appropriate?
The request is that we hide the counselor, despite that's not what Your Honor specifically ordered.
Well, and I'm looking at our most recent temporary parenting plan, and it's joint decision-making across the board, and that information should have been provided to the father already. So I am going to authorize that release, and since, so it needs to be to Miss Baldwin by the close of business on the 16th. The name, address, phone number, the counselor, and an ROI needs to be done no later than close of business on the 17th.
I actually do not have the name of that counselor.
Okay.
So it should just go to both of us. And then is the court ordering regular visits? So this isn't a one-off.
This, yes, this should be, this child is exhibiting concerns that I think need to be regularly discussed with the counselor. Obviously, after continued visits and the counselor says, okay, that's fine, but I don't know that we're there yet. And I haven't gotten anything to show that we're there yet. So yes, these should be regular appointments, whether that's weekly, every other week. Obviously, the counselor, I hope, would make that determination based on the need and availability. But they should be regular, ongoing appointments as needed.
And if I could ask for an ROI for me also for the counselor.
That's fair.
No objection.
All right. Anything else on this matter today?
No,
No,
I'm
Your
trying to prepare a cleanup order and we'll just present.
Hi,
that.
Your Honor. I have video or I have voice today again. So I did get here
Okay.
early, but at least I got something. So
Well, good. All right. We are here in there's a contempt that's been filed,
yes, that's correct.
and I reviewed, I believe, there was a few things that showed up late. So there's a confirmation of a parenting class that was just filed yesterday by Miss Erickson, and witness list that has nothing to do with today. Okay, so I've reviewed everything, and I guess I will start with the moving party.
Aaron Winkles on behalf of Aaron Anderson. So we have been here. This is our motion for contempt, and we've been here a number of times. It originally started in the parentage action when we had to file a contempt in order to get genetic testing. At the last moment of the 11th hour, the child had genetic testing. The next stage, Your Honor orders a very specific framework for how the parties are supposed to deal with each other, and how visitation is supposed to go in reunification. And what mom does is she essentially tries to find any excuse to not have it happen. And then what she does is she waits until contempt and then files a couple of days early, goes and does at least a part or a portion of what she should be doing, but she's not doing the entire thing. And so then we end up back here in the contempt. And I say this because you can see in your own order that it was very specifically written that there was to be an ROI, that the evaluations were to be collateralized with dad and the GAL. None of that happened. And so mom's excuse at this point is, well, I told them, I gave them an ROI. I'm not sure why you didn't call them. Well, my client nor myself could call because we had no idea, number one, where it was. It just happened recently, even though Your Honor ordered this back in May. Nothing's kind of moved forward. So my client is always forced to come to court for contempt. Then we have the fact that he has had not one single phone call with his child, despite Your Honor ordering that he was supposed to start telephone visitation. Those are kind of the minor things in comparison to what's happened with visitation. My client's had absolutely none. So my client immediately left court and went out and put money and started seeing Allison Long. He went to a number of sessions with Miss Long. Miss Long tried to contact Brittany Erickson. It appeared that everything but the dog passed away. Everything was sick. Every excuse in the book, she never made it. My client waited 2 months to see his kid, 2 months to even start the process. At some point, Allison Long emailed back and said, I can't do this. I'm out. It is nothing to do with Mr. Anderson. It is not, I can't tell you anymore because there's no ROI. So then my client goes to Charlotte Rosen because he's just trying to see his child at this point. And again, Miss Erickson, as she always does, she waits to the very last moment. I believe she has an appointment today. In any event, this is what she's doing. She does not want this child to meet her father. And so because of that, anytime she can delay, she will. Now, she claims she doesn't understand this is not a woman, that this is her first rodeo. She's been in several dependency actions. She's been in a parenting action. She did the same thing in that case. My client has attached it to his reply declaration. On top of that, I mean, these two were supposed to have almost a joint visitation, and really they were supposed to work through things. And Miss Erickson's excuse is always the same. Your client was a drug addict. Your client was an abuser. My client has been through parenting classes, DV evaluations and treatment, relapse prevention treatment, drug treatment. My client has been clean for over 2 years. My client is not an abuser. He's gone to every single class that he can. He has a counselor that's monitoring him. He has literally done every single thing possible to see his child. He has stable housing. Miss Erickson doesn't. Now, she self-disclosed to this court that she was on Suboxone of 16 milligrams, yet when she did her hair follicle, it came out as 0, even though it was the extended panel with the Suboxone. I can't pronounce it, pro something. In any event, my client, the way the order was written, Your Honor, was that it was very specific. If you don't take this child to reunification counseling, even if the child is sick, if you're sick, if you don't take this child, it's a contempt. That's what your order said. She's never taken the child. She's never gone. And it's been now 3 months. And that's another 3 months added on to the parentage, added on to the rest of it, where my client doesn't get to meet his child. I'd ask Your Honor to actually change the parenting plan. Vashti was on this before and acknowledged that withholding the child would be a problem. And if so, she was talking about moving from a 50-50 plan to immediate change in custody to my client. While it would be traumatic for the child, we are very concerned as to why mom isn't taking this child. Is there an issue? Mom has a significant history of heroin use and meth use. She has lost 2 of her children in dependency, so we are quite concerned. My client would ask that you consider change in visitation, change in custody after speaking to the guardian ad litem.
All right, thank you, Mr. Roberts.
So with respect to the JL, she's off the case. Ms. Winkles requested she be relieved on my first hearing, which I didn't have any context at that point to object or say anything about that. So I think any comments or references to the JL at this point are outside the scope of what the court can and should do. There's a lot to cover here. I was a little confused about the reply declaration filed by opposing counsel because there were some quotations, and what Ms. Winkles is arguing to the court, as far as I understand it, is that my client was very clear about the ROIs and the collateral input, and that, as she mentioned and put in her reply declaration, my client's declaration makes clear that we filed the evaluation with the understanding that the evaluation was not complete. We also filed the ROIs that were dated, at least most, if not all, were dated from May, which if she was not even going to sign them on time, if she was trying to interfere, but the ROIs were signed. The only language about timelines with respect to the evaluation states if respondent, my client, fails to obtain the report for 6 months, that puts us out in December, then petitioner may request visitation cease. We're not there. We're not in December. This was filed in July. My client got an evaluation that was admittedly incomplete, but has provided the ROIs and notified who the evaluator is to opposing counsel a month or more ago. I'm still unclear if father has even reached out to the evaluator since this period of time, knowing the ROIs have been signed and who the evaluator is. And if he hasn't done that, then I really don't understand what's going on here and how he can point the finger when he hasn't followed up. And I've received no information of him following up. But still, we have a 6-month time period where we're not there. She hasn't failed to comply. She has been within the parameters. And if the evaluation is not completed by December, then we have a problem. With respect to the ROIs, I just want to mention there was some confusion. I know Ms. Winkles is bringing up a prior court order from 6 years ago when my client was having substance abuse issues as some kind of consciousness that she knew exactly what was happening 6 years ago when she was having a life crisis. However, in the exhibit that we attached from Mary Ferris from Columbia Wellness, it corroborates pretty clearly my client's position that at least some of the staff at Columbia Wellness is not operating, let's say, perfectly. This caused my client frustration, as Ms. Ferris says, and quotes, rightfully so, as she has been trying for some time to get the matter settled, end quote. So I don't think there's any evidence in the record to show that my client was intentionally delaying with ROIs. She was confused. The information has been provided to Ms. Winkles and to father as of, I believe, 5 weeks ago now, if not or so, and the evaluation can go forward if he hasn't reached out already. With respect to reunification counseling, Ms. Winkles says that Mr. Anderson had a number of sessions with Ms. Long. That's false. I spoke with Ms. Long because I was trying to figure out what we could do to get things back on track. Ms. Long disclosed to me that there was a $100 or $150 initial history overview. I communicated this to Ms. Winkles. There were no sessions with Ms. Long whatsoever, other than the initial overview. Can we take the case? Give me the history. There were not multiple sessions. There was the therapist in the office that he was doing therapy with, which I think he still is doing therapy with. We're not disputing that, but I do have to bring that to the court's attention. I believe I have emails to that effect as well. That was communicated to Ms. Winkles. With respect to Charlotte Rosen, as we put in my declaration, I reached out to Charlotte Rosen as early as July 7th when I realized that July 7th, excuse me, when I realized that Allison Long was no longer an option. I never heard back from Charlotte Rosen despite following up. My client finally did hear back, and she has an appointment. She had the appointment arranged last week after following up with Miss Rosen multiple times. I emailed Miss Winkles that with screenshots of her calling and not getting responses back. She finally got the appointment. I wouldn't consider this a last minute contact with Miss Rosen. I received no information from Miss Winkles that father had started with Charlotte Rosen until I reached out and asked what's going on here. And I had my client proactively contact her, which she has, and she has an appointment today, and I expect that to go forward. With respect to the order and reunification, Ms. Winkles, I believe her argument today was that the order was clear that if you don't take the child to reunification, then there will be contempt. I'm confused about how the reply declaration is written, because on page 3, the reunification counseling section of the reply declaration, there is a line 17. I reiterate the court's words from the last hearing. The first 2 paragraphs of that section are from the parenting plan. I don't know what the last hearing we're referring to. The last hearing I was present at on the 6th when the order was entered. I was retained just before then, so I had nothing to do with reviewing the order, et cetera. I was brought in the last minute, but the first 2 paragraphs are from the parenting plan itself. The 3rd paragraph, which I assume Ms. Winkles is trying to highlight, which has bolded and underlined language, the implication I'm kind of reading from this reply declaration is that it's in the parenting plan. That language is not in the parenting plan. That may have been language that was at a prior hearing that's not in the minutes, nor is it anything I can gather, but that's not in the parenting plan. So I just want to be clear to the court, so the court's apprised of all the possibilities here. And then the 4th paragraph with respect to Talking Parents app, the first sentence is from the parenting plan, with the sentence saying the parties shall begin using this app no later than May 25th. That's not in the parenting plan. So my client's understanding was there was domestic violence between the 2 of us before. On behalf of Mr. Anderson, was domestically violent towards me. There's an existing protection order in another case active right now protecting me from Mr. Anderson. When reunification counseling starts, the phone visits will start. And that's my understanding. That was what my client wrote in her declaration. But these pieces of the reply declaration, I'm not sure what they're referring, but they are not referring to what's in the parenting plan. Excuse me, I'm just double checking my notes. With respect to the hair follicle, I think it's curious that this motion was filed prior to the timeline even lapsing. There was no email to me asking if my client was at the facility or anything along those lines. My client, we received I believe this was filed just before the deadline for her completing her hair follicle. She was at the facility within the time period. The test was done by a professional. There's no evidence of foul play. The accusations are just speculation and conjecture, apparently because Mr. Anderson doesn't like the results of this. She's clean. We submitted evidence of her Adderall prescription, which is the positive on the test. And that should be the end of it. And it really should have been brought prior to the results being available on anyway, or being able to confirm whether she did or did not comply with showing up at the evaluation. And that's why my client asked the court find this to be the abusive use of litigation, because this was filed prematurely before the answer about this issue of contempt could even be known. I'd ask the court not to find my client in contempt. The reunification counseling should be starting this week, subject to Ms. Rosen's availability to get things started. My client has an appointment at 5 o'clock, and that should be controlling about what happens going forward.
Brief reply, Your Honor.
Sure. Thank you, Mr. Roberts. Go ahead, Ms. Winkles.
Yeah, so if we look at the order, you'll notice that what they're attempting to do here is to make a semantic argument that essentially picks at what Your Honor ordered. And that is exactly what Ms. Erickson keeps doing, is picking away at something in order to find a loophole. If you'll notice from my client's declaration, his reply declaration, he puts what the court specifically put in the order under the limitations on a parent. The evaluation, mental health and drug evaluation, both evaluations with collateral contact from the GAL, petitioner, and other fathers of the respondents' other children. The report will not be accepted without collateral contacts having been interviewed by the evaluator and documented in the report. This is in the court order. And this specifically gives you a map of what you're supposed to do. Now, as I said before, Ms. Erickson has already been through several dependencies, already had several parenting plans, and got in trouble for this very thing before she already spoke to the GAL. That's in the parenting plan. The rest of it, in the wording that says, I reiterate the words of the court's last hearing, that was Your Honor's dicta. And that laid it out in no uncertain terms what the court expected from Ms. Erickson. You said, not having a ride, having other commitments is not an accepted excuse. Failure to bring the child to regularly scheduled visits will be a contempt of court. We ordered the transcripts. Those are Your Honor's actual words. You were very, very clear, considering the history in this case, about not showing up late. And that's exactly what's been done again. Waiting 3 months to go get an evaluation is absolutely ridiculous when Your Honor wanted this child and this man to start reunification at some point. The fact is that you can see from her own text messages that she submitted, her mom's sick, she's sick, the child's sick a number of times, everybody's sick because she doesn't want him to have contact. Your Honor states in that parenting plan that they are supposed to have telephone contact between father and child. In that DVPO, again, they said family law action controls. So I'm not sure what the issue is there. And I would take a little bit of pause to state that I said something that wasn't true. My client has been seeing a counselor at Allison Long's office since he first met with Miss Long. She has staff that works there as well. My client still goes. He has a declaration from her. He went through that process there because that is where everybody chose. And then suddenly she doesn't want Miss Long. She has problems and so forth and so on. This is clearly a contempt by Your Honor's own words in court, that if she didn't do A, B would happen. Well, she's done nothing of A. She's done absolutely nothing. And she has all these things that are going to happen. As soon as we get done here, if there's no contempt, she'll do the same thing again. I'll be forced to bring another contempt, and the merry-go-round will continue going on. So I ask Your Honor to find her in contempt. It's clearly a contempt. Thank you.
Can I briefly respond, Your Honor?
Very briefly.
Just about the court order. This was an order drafted by Ms. Winkles. The only time limit for any of the evaluation related things says 6 months. If it's not completed by then father can ask that there be no visitation. Without there could have easily been mother must meet these requirements time-wise, 30 days, 15 days, 45 days. Those aren't in there. So it's not that we're splitting hairs. It's the fact that the order doesn't have any time limit other than the 6 months for the evaluation to be completed. And to say when your own order is the one that does not have a time limits, saying now we're in contempt because 4 weeks later it's not completed, that doesn't seem to rise level of contempt from my perspective. So I would submit that to the court, and your position on what your dicta was, I'm not going to comment on that because I wasn't there.
All right. Thank you very much. So I tend to agree with Mr. Roberts as far as the 6 month time frame. Should it hold everything up if it's done? No. It sounds to me like there's an assumption that Ms. Erickson knew what she needed to do and didn't do that. And I'm sure that's going to be the standpoint of the petitioner in this case, as far as the drug and alcohol evaluation. It would make it difficult for Mr. Anderson to weigh in on any of that if he has no idea where she went and had that evaluation, when she had that evaluation. So it seems a little interesting that wasn't provided until just 5 weeks ago, when this order came out of a late May, early June decision from the court. So technically she still has time. There's time for the collateral contact to occur now that the ROIs are done. And I encourage Mr. Anderson to do that. So the reports can get filed with the court. As to, so, sorry, let me.
The telephone contact with the child. So no.
Yes, sorry, I'm getting back to where we're at. Or the list of issues that were raised in the contempt. And they were lost in Odyssey for a second. Doesn't appear that the decision-making, there was no real response to that mom has included father in any decision-making. So that doesn't appear to have happened. Really what's most concerning for the court is the reunification counseling. So we're 2.5 months after this was supposed to start, and it was supposed to start within 14 days of the order. I am going to make a finding of contempt based on that, and it does not seem that it seems to the court that Ms. Erickson is delaying intentionally the efforts to get this process started. So I'm going to make a finding in contempt based on that. In the language, the hair follicle, she was, I'm not going to make a finding of contempt on the hair follicle. She appeared on the day that it was ordered. Her test declaration indicated that she was there before 3, but couldn't get it taken until after 3, if I remember correctly. And there was she had kids that she had to deal with as part of that. So we got the hair follicle because it wasn't done by 3. I'm not going to make a finding there. One of the things I do see in the parenting plan that is a little, I guess there's a little bit of a wrench, and I guess I would ask the parties. It says the father shall have weekly video visits with the child through Talking Parents co-parenting app. And this should start the week after the petitioner has met with the above counselor. So we have him seeing someone at Miss Long's office, and in the order it suggested specifically Allison Long, Charlotte Rosen, or other licensed counselor. So I guess my assumption, and I guess I'll give Mr. Roberts an opportunity to respond if you want, is that because he's met with Miss Long and continued seeking counseling from someone in her office, that that would comply with the visitations, the telephonic or video visits should have been started months ago. Is there any concern there?
My understanding is that, and my client's understanding, I believe it was spelled out in her declaration, is that the phone calls were part of the reunification process, and the reunification counselor would be facilitating the calls. My client and Mr. Anderson have a very tenuous relationship, and she doesn't want contact with him other than what's absolutely necessary in this plan, in the parenting plan. And that her understanding was that when the reunification counselor is on the case, then they facilitate. If I was there for the entry of orders, I would have nitpicked about within 1 week. It would have to be consistent with the reunification counselor's schedule. Yes, there's a therapist in Miss Long's office that he's seeing, but they're not a team, and they're not on a reunification team. It's a individual therapist that's doing individual therapy for reasons unrelated to reunification. I'm sure he's talking about things that are to get back with his child, but it's not part of the process. So I take issue with the way the order was written. I know it's late for that, but for the purposes of contempt and for the purposes of going forward, I think it's important to know exactly what's going on here. I read it as this is part of the reunification process.
And Your Honor, the order clearly states that after starting with Allison Long, that, or not, that there's going to be this process that goes through. Now, I didn't write this order, the GAL did, and we just accepted, Your Honor, ruled that the GAL's order was to be incorporated in full. And that's what's happened. It was very clear. My client started it, but for Ms. Erickson, having everybody get sick, everybody ill, not being able to go, having this, having that, having a headache, that process would have gone. It was Ms. Erickson's but for that stopped the reunification counseling, or else this would have been 2 months down the line already. So she can't say, well, I'm not in contempt because we didn't go through reunification, when it was her fault that they didn't go through reunification. That doesn't seem to work. And again, the GAL is the one who incorporated this, the one who crafted this order. It was essentially ordered in full, and that's what's there before the court.
Right. So I guess I'm frankly concerned that Miss Erickson and her willingness to have anything to do with Mr. Anderson. So I'm going given the delay that he's in counseling, I'm going to authorize that those video visits through the Talking Parents app start. It says Tuesdays, 6 p.m. for 5 to 15 minutes. So today's Tuesday. So that should start this afternoon. And then we need to get reunification counseling started. I want to review this on the 29th, and there better be an appointment for the parties ready to go. And I know there's, I guess, one today that Miss Erickson's going to, and I don't know if that's just her or if that's the child, what that is about. But I want more information. So I want to review this on the 29th to ensure that we have something started. I understand the tenuous relationship between parents. That doesn't have to be the case with the children. And I'm really concerned that this child is not getting a fair shake to know both of his parents because of that relationship between the parents. So we're going to review this on the 29th, 1:00 p.m. And I want an update. I don't care if it's, as long as all parties receive copies of it. I don't care if it's a last minute emailed update that's filed after court. Just want to know where we're at and that the process has actually begun. And that can also be presentation for the contempt.
Thank you, Your Honor.
Your Honor, with respect to the calls, I'm concerned about the way to facilitate them. Could my client have someone known to the child facilitate the calls? So it's not her herself.
Ms. Winkles, you want to weigh in on that, or?
I don't mind as long as the calls happen. Normally I would be more than willing to facilitate as well with Mr. Roberts, but I've been out because of a number of surgeries. I am back now if Mr. Roberts wants to do that instead, or, where we can both get our clients the application so they don't have to talk to each other, or to have a third party do it. As long as those calls occur on time, I have no problem.
If Ms. Erickson feels that she has someone that is willing to facilitate that phone call, and I guess Mr. Anderson needs to understand that first phone call may not result in a whole lot, but as long as Ms. Erickson is comfortable with someone doing that to help facilitate the phone calls, that's perfectly fine.
Okay, thanks for the clarification.
All right, we'll see you in 2 weeks. Ms. Roberts, are you ready to proceed? I know there was a late filing by Mr. yesterday.
I have reviewed them, Your Honor, since we're just here for a review in hopes of moving forward with additional parenting. I think the court has everything before it. I don't think there's anything additional that would be helpful at this point. I think we can just move forward with where the court wants to go from here.
All right. Does anybody need the argument time?
I think the pleadings are very clear, Your Honor. The declarations are clear. I'm not sure how much more. I'm happy to provide all the argument Your Honor wants, but I think that it's clear that the visits are going well. I don't see anything in the pleadings that have been filed that would indicate a danger to the child to move away from the supervision, and would request that the court adopt my client's proposed uptick for the parenting schedule as set forth in her declaration. If there's questions Your Honor has, I'm happy to answer them, but I know Your Honor has a very full calendar today.
I guess I am going to ask you a few questions. So why is mom on her phone during the visits? It seems like everybody is saying that she's more occupied with her phone than her child during the visits. What's that about?
That wasn't in her, the person who has been supervising with her, because the parties have been having two different supervisors, right? There's a person that Mr. Hill sends and a person that my client has go with her. Obviously the visit is supposed to be centered around the child. But I think my client would dispute that she's on her phone during the visits.
And then response to the one visit that was everybody thought was until 12:30, and she said no, it's only until 11:30. So parties believed it was an hour short.
So again, I did not have. I went back and looked through the emails. This, as Your Honor knows, the scheduling of these visits has been complicated, complex, numerous. It's involved the attorneys on both sides. The coordination has been incredibly difficult. So without going back through all of the numerous amounts of communication, I mean, it could have legitimately been an actual error on both parties simply because of the level of complexity in getting these scheduled. I mean, these were scheduled last minute sometimes. They were scheduled the morning of, they were rearranged. There were times when the child was ill. There were times when certain supervisors were supposed to supervise and then they weren't available at the last minute. So I don't believe that one instance had anything to do with an error on anybody's part. It literally could have been just a miscommunication, either in the communication going on between the offices and trying to facilitate all of this. You know, both Miss Bliss and our staff has been very helpful, you know, trying the best they can to facilitate this, but, you know, doing things last minute can obviously sometimes create a little bit of chaos and misunderstanding. So I don't believe that was either. I don't think the court should view that as an error on Ms. Hill's part or an error on Mr. Hill's part. I think it was probably just in the context of everything that's going on.
Ms. Bliss, is that fair?
Yes, Your Honor, I think the issues with scheduling have largely been resolved. The parties are now communicating, it's my understanding, amongst each other. I believe in our Family Wizard app. So I think the complexity has changed. I think that the supervisor that the parties have agreed upon, I think a lot of the waters have calmed, at least at this point. So I don't think that there's a lot of issue there. Going back to if you wanted an argument or not, I don't have any argument. I can just rest on my pleadings, but I do just want the court to consider Marshall's concerns and his concerning behavior that my client listed in his declaration yesterday. There's ongoing need for counseling in this matter. Your Honor initially ordered reunification counseling, knowing the timeline of that. Your Honor wanted to reestablish visitation in the interim, which is why you ordered supervised visitation. Now that we have a reunification counselor established, I would ask that move forward and that no changes to the supervision, visitation occur, or Your Honor removes that given the concerning behavior contained in my client's declaration yesterday with Marshall's statements of hurting himself, his family members, an issue this past weekend with his younger sister being taken to the emergency room due to some behaviors. There's a lot of concerning behavior here that Marshall's working with his individual counselor currently, but I think working with mom with another counselor is necessary, at least at this point. My client would ask the court to either remove the supervised visitation and restrict it solely to the reunification counseling or maintain the status quo pending that reunification counseling moving forward.
I could just respond briefly to that piece, Your Honor.
Okay.
With respect to the reunification counseling, we, you know, at the time my client filed her declaration, we hadn't received confirmation about that. That is moving forward. So I wanted to make sure the court was aware of that. I do agree with Ms. Bliss that is moving forward. With respect to the other things in father's declaration, obviously my client hasn't had an opportunity to put that in writing since we just received that, but she would caution the court in the fact that the child's counselor did provide a letter and notes. None of those, you know, the only thing the counselor talks about is some statements that Marshall has made related to, you know, I will just say feeling as though he's sort of in the middle of his parents' conflict. I don't, you know, my client is acting and doing everything she can to not put him in that. She understands that she's not to be talking to Marshall about this or any other case. I don't see anything in any of the documents with respect to any of the supervisors that indicate that. As far as, you know, the other statements in Dad's declaration about Marshall's behavior, there is no pending motion before the court for a immediate restraining order or any such pleading. So I don't believe that issue is appropriately before the court. I would assume that if there was an emergent issue related to Marshall's health and safety, that would have been brought by now. Thank you.
So I did see the counselor's letter. That's was frankly very concerning. concerning in a lot of different ways. I think it may be a really good idea for Ms. Hill to reach out to that counselor, touch base with them, because I just think that would be a good idea. I'm glad reunification counseling is on board. I'm going to leave everything as is at this point. I'm not going to increase visitations. I don't think, I'm glad visitations are going well. Do I think they're going amazing? No, I don't, based on the reviews of the reports that I've seen. I think especially when we're having some increased anxiety and behaviors from this, from this young man, I want to make sure that he's as insulated and has as many outlets as possible as he progresses through this. And that's frankly who we need to be concerned most about. I frankly really hate children are resilient and they'll get over it. They shouldn't have to be. They're the child and there's adults involved. Adults need to adult. Child shouldn't have to be in the middle of that and shouldn't have to also adult. So I'm going to leave everything as is. Visitations remain as they were previously ordered, and then there'll be additional contact ultimately when reunification counseling is up and in full swing. And then as soon as we get some more information and it's appropriate to dial up visitation, then I'm happy to look at that and reconsider that. But I'm concerned with some of the behaviors and statements that this young man's making, not only to family, but counselors. And so I want to move forward with him in the forefront of our minds as far as what we do. So status quo, that's where we're at. How long, and maybe neither of you will be able to answer this. Do we have an initial appointment for reunification, or we just have somebody that's taking the case and that's all getting worked out?
I don't have any knowledge of that, Ms. Roberts, do you?
I just know that he was anticipating being able to start in August, but I don't have a specific date. But I will check in with the counselor's office again to see if he's been able to set that.
The sooner that gets started, the sooner we get more information, the better able the court is to make any changes that benefit hopefully all parties. So, all right. Do we need any dates set, or if parties can note it up once we get some more information?
We'll renote it once we have that
In
information.
which we were
All
originally
right.
before you back
All
on
right, good
April
luck,
11th regarding reinstituting my client's visitation under the 2018 parenting plan. Last spring, court gave him a couple of to-dos that you wanted to see prior to jumping back into what I guess can be considered a normal visitation schedule. And my client has largely done that. First and foremost, you wanted him to get updated and get a couple more domestic violence classes under his belt. He's done that. He's provided you proof of completion with that. Showed you that he did that very timely, reached out with the provider, did what he was supposed to do, and we filed the certificate as evidence with that. Second of all, pending a review hearing and the domestic violence update, you wanted him to go through some professionally supervised visits through reconnecting families. Again, he's done that. We provided you with a copy of those reports from Ms. Fellows and her staff, which are glowing, showing that it took very little time, if any at all, for Ava and Mr. Stone to pick up in the relationship right where it was, again, in the capacity that he detailed for you last spring. So here we are, and we're asking that the visits be extended, that go back to the regular 2018 parenting plan. You see, and this has been kind of the theme of this case, a lot of back and forth between the parties. We could spend ample time detailing that. My suggestion is it's largely irrelevant. That relationship is over. It's been over for some time. My client's relationship with his child is really all that matters, and all the information before you shows that this relationship between the two of them is extremely strong. In fact, so much so that Ms. Fellows notes there is a tangible father-daughter relationship and rapport. The notes indicate there's a lot of laughter, a lot of chatter, that there's very little downtime, and that the child is exceptionally comfortable. There's really no reason to limit visits. There's no reason to have this phase-in approach as we commonly do, because again, we have a case now where the child is very closely bonded and very comfortable with dad. So we are asking you to renew and reissue the existing plan, which again is my client having overnight visitation with Ava on the weekends, in addition to every Wednesday for a couple of hours. We think that's appropriate given where we're at in time currently. I would also remind you that at the last hearing in the spring, there was some conversation back and forth about appointment of a guardian ad litem. If we want to do that, my client is on board with it. He details for you some health struggles or hiccups that he had throughout the month of July. That's impacted a little bit of his visitation with Ava. He has more procedures coming up, but nonetheless, nothing that's going to impact his ability to be there for the child, and he will largely work around those. So that's where we are on our end. Again, my client has done everything that was asked of him and then some, and we do believe it's time to graduate to the next step, which is resuming a normal relationship with this child.
Clarification, I guess, is there a parenting plan that was entered post 2018 that we've been, okay. I just want to make sure I was looking at the right thing. All right.
I think
Thank
that was
you.
the first that was entered.
Okay. Ms. Baldwin, good afternoon.
Good afternoon. For the record, I'm Chelsea Baldwin. I represent Ms. Robario, who's the mother and primary parent of the child at issue today. The court's correct. The last parenting plan entered in this matter is the 2018 parenting plan. That plan makes findings against Mr. Stone regarding domestic violence, as well as abuse of conflict. This appears to have been done as a result of a trial with a previous Judge Cruiser presiding over that trial. So these are findings that she made. As a result of those findings, she required evaluations and treatments to be done as a result of those evaluations. And instead of doing those, Mr. Stone just did it. He declined to do those. And so we have this essentially 5-year period of time where he just ignored the court's order. My client testified previously. He stopped having visits in 2021 when she fully understood what the order meant and that he had to comply to get visits. And then from 2021 through 2023, so then 2 years essentially without visits. So that's an extended period of time where he knows what he has to do and just continues to blow it off and just say, well, it's not that important to me to comply with the court's order. Finally, we see him in June of 2022, so 4 years after the court's order, finally getting a domestic violence evaluation. Again, this is about a year of not seeing his child. The evaluation recommends treatment. He doesn't like that evaluation, so doesn't do any treatment, continues to not see his child. Again, continues to essentially neglect those parenting functions. Finally, gets another evaluation and for domestic violence that he likes a little better. No indications that he fully complies with that evaluation. It's not until your April order of this year that he finally completes everything, or finally you sort of dictate to him, you have to complete it to move along. And it's only essentially now that he's completed everything. Here we are 5 years later. This is not a modification. So we're not modifying the 2018 parenting plan, but what the court did do in that 2018 parenting plan was reserve what to do with noncompliance. We have a 5-year history of noncompliance that had some pretty significant impacts on the child of this case, where Mr. was not involved in her life for an extended period of time. There are serious concerns that while Mr. has turned in his online certificates of, gee, I took the class and I checked the boxes and I clicked along the little, PDF thing, there's serious concerns that no lessons have been learned here, and that we have a reality of a high conflict relationship that continues. And again, the court's made those findings already of abuse of conflict. The supervised visits stopped July 5th. That was the last visit for my client. I appreciate Mr. Zanny trying to sort of pass that off as a medical issue, but then also saying it's not so severe it interferes with parenting. Well, it's going to be one of those two things. Either he just decided he wasn't going to see his child for 6 weeks, or his medical condition is so severe it is significantly interfering with his ability to see his child, because we've now gone 6 more weeks without child seeing Mr. Even though he has a court order that allows him to do so, he's just declining to do that. Similarly, he's declining to use Our Family Wizard. Ordered that back in April. Mr. just is not going to do it. Can't make me. And that's a very similar behavior that we had from 2018 to 2022. Can't make me. You can order it, but can't make me. And really child bears the consequences of those actions. So in this case, my client continues to have serious concerns. She doesn't want to prevent relationship with child and Mr. She does want it to be safe, and she does want it to be healthy. So at this point, my client wants to see visits move forward, but not sort of an all or nothing. We're not really in a good position for that. Mr. has just finally shown compliance. We should ease into regular visits as outlined by the 2018 plan, but we shouldn't go from a 2-hour supervised visit and now again 6 weeks with no visits to, hey, you're going to have child for overnight and maybe you're not even healthy enough to be able to manage that. That seems like a pretty concerning situation. So we'd ask the court to construct a visitation ramp up back to the 2018 plan that's slow and methodical. Similarly, Mr. should be required to comply with the use of Our Family Wizard. There shouldn't be contact between these two parties. That's part of the 2018 order. The 2018 order says the only thing that Mr. Stone can contact my client about is childcare. it specifically says he's restrained from having contact with my client except regarding childcare. So again, my client just doesn't want that conflict that the court already found was an issue on Mr. Stone's part. Finally, regarding his heart issues and cardiac issues, those appear to be somewhat serious. He should be required to notify my client via our family wizard, if he's not able to parent the child or he's hospitalized. It's not reasonable that he be so ill that he's not even caring for the child, and essentially is just saying, well, I'm going to engage in this conflict that the court's already found, and just not tell anybody or not tell mother. That's not reasonable. That's not a reasonable course of action. And again, it goes back to the things that we had hoped Mr. Stone had learned over those classes and just really hasn't, or at least hasn't exhibited that he's learned those things. So we'd ask the court to create a schedule that allows it to move from the 2-hour supervised slowly to back to the 2018 plan. That should happen over at least 3 to 5 months. Again, when we're having very minimal time and still sort of these conflict issues. I think that that's a reasonable request on my client's part.
And I'm going to use client Ms. Baldwin's comments from an earlier case. In this capacity, it's time to move forward. Certainly, it's time to move forward. 95% of the arguments that we just heard were the exact ones that the court entertained back at the hearing in April. Court's been over this. The court had credibility issues back then. My client provided you information that shows immediately after the trial in 2018, these parties got back together for a period of time. Thus, there was no real parenting schedule. Thus, there was no agreement as to what was going to happen and what was not. And he was seeing his child daily for extended periods of time. Back in April, we gave you pictures and commentary and the like, validating that. So again, to suggest that my client went 5 years while abandoning his child again is quite simply nonsense. Moving forward to our family wizard, that's already been in order. My client is aware of that. Find it ironic that it's Miss Ribeiro who claims that there's this abusive conflict, that she wants to avoid all of that. And what does she do? Again, we get an information from Ms. Baldwin indicating that my client had somehow violated that, when come to find out it's Ms. Ribeiro who's reaching out to him, and they're having a 4-hour telephone conversation related to this child and whatever else people can talk about for 4 hours. She then communicates with him again several weeks later. But here we are now in August, after my client has done absolutely everything he was supposed to, and we're rehashing the exact same things over and over and over again. Again, this is not about my client's relationship with Ms. Ribeiro. He wants nothing to do with her. He wants nothing to do with that. That is water under the bridge. What he's concerned about is his relationship with Ava. That's what's important to him. That's what we're asking the court to preserve. And again, by all intents and purposes, this is a case where my client has always had a strong rapport with his child, has always had a strong relationship with his child. And that's evidenced throughout the visitation notes. He's gone through the parenting class. He's gone through the domestic violence treatment. He went back again to fresh up on that after the court back in April told him to get a couple more hours. He did that. He's done everything he's supposed to and jumped through every hoop again because he values and wants to preserve this relationship with his child. That's where we're at. There's no justifiable reason not to give him overnights, to not reinstitute that 2000 parenting plan, other than Ms. Ribeiro just wants to hold it as a control mechanism over him, as she's done since 2018.
All right. So our family wizard is ordered. That needs to be used. If I guess, barring any protection order that's in place that is beyond this parenting plan that was ordered in 2018, I guess if the parties want to have a civilized conversation, I guess that's on them. But everything needs to go through our family wizard for visitation. Here's what I'm going to do. I'm going to, especially since we've had 6 weeks here with no visitation, and we were supervised visitation for an extended period of time, I am going to ramp it up, and I'm going to try to do it relatively quickly. So I'm going to start with, we're going to move to 4 hours a week unsupervised for 3 weeks. Barring no issues there, then 8 hours a week unsupervised for 3 weeks. Then 1 overnight a week, Saturday to Sunday a week, and a Wednesday evening visitation for 3 weeks. So within just over 2 months, everything's going well. The next step would be reverting back to that parenting plan from 2018, since that's what we're working with.
So
So the only issue with that is phase 3 if it's every week, Saturday to Sunday, and every Wednesday for 3 weeks is more than he's currently getting under that 2018 parenting plan. That's every other weekend, just so we're all on the same page.
Right. That would be exceeding his allowed time under the 2018 plan.
Okay, so the
So
last
I
phase will
can't-
be 4 weeks instead of 3. And it'll be every other, so it'll be just like the parenting plan, except for 1 overnight instead of, and I believe
He only has one overnight.
it's 1 overnight anyway, so. And
But
it's,
what I will tell the court is that more than likely we'll be filing a petition to modify based on him meeting those requirements and accomplishing the 191 factors and the treatments for those, which would expand that. I planned on doing that sometime in the fall, depending on what the court's order was today. That might impact where we go in time. If we want to just leave it at the phase 3, I assume or anticipate that we'll have that filed by then.
Court can't make advance rulings on things that haven't been filed and it hasn't seen.
I'm
So
not
I-
asking you to. I'm just saying that instead of maybe 4 steps, we go with 3 steps.
Well, the court's really only given 2. So the court's order, the way you've outlined the order is 4 hours, then 8 hours, and then frankly, the 2018 plan. Because you're intending to give a single overnight, but that is the underlying order.
yeah, and I initially read it as Friday to Sunday. So that's why I was gonna start with 1 night overnight. And then when I looked again, it is only 1 overnight. So it's essentially 2 steps and then back to the plan.
And then I did want to clarify, so for the 4-hour visits, is your honor intending for those to be every week for 3 weeks or to alternate weeks?
I would like, starting out, I'd like every week, because that's,
Okay.
I'd like every week for the 4 hours, and every week for the 8 hours. That can be broken up. It doesn't need to be at one time. Hopefully the parties can work together to schedule that.
I would ask that the court order on because we'll be back in school by the time those 8-hour visits start, that they can't be every weekend, essentially, so that, because otherwise my concern is my client doesn't have a weekend with a child for essentially a month and a half. So
She's
once
done
they get
every
to the
weekend
8
by her
hours,
design for the past 2.5 years. So I think 3 weekends back to back probably isn't unreasonable given the circumstances.
Yeah, I'm gonna stick with what I ordered. So 3 weeks, 4 hours a week, 3 weeks of 8 hours a week. And then 2018 plan kicks in barring any motions or concerns from either party.
right? So I guess I would clarify.
Presentation
Well, hold on. I don't think the court understood my request. My request was not that he not.
I don't care that, if she gets no weekends for the first month of school, no full weekends, then she gets no full weekends for the full month of school, first month of school.
The problem is the court's ordering them to cooperate to create a visitation schedule. And I have concerns
Okay.
about that being possible.
All right, 8 hours every Sunday from 10 a.m. to 6 p.m.
Okay. And is the court ordering the same for the 4-hour visits? Like,
I can do that. It can be every Sunday. And I don't know, Mr. Zandy, if your client doesn't work on the weekends?
You tell him what to do and he will do it. He wants time with his child.
All right.
If it's Saturday, fine. If it's Sunday, fine. If it's anything else, that's fine. I'm not going to nitpick that. Whatever you decide is good with us.
All right, then we'll do 10 to 2 on Sundays for the 4 hours.
okay. That's easier because I don't think they can communicate effectively.
And if for some reason they decide they can, and that needs to be a Saturday by agreement versus a Sunday, I don't have a problem with that. Or if it needs to be 11 to 3 because of by agreement, again, don't have a problem with that, but that obviously assumes that they would be able to work together, and sounds like counsel's concerned that may not be the case, so.
An exchange at Walgreens pursuant to that order probably makes sense for simplicity.
There shouldn't be any changes to the exchanges.
Okay. And
I'm sorry,
presentation
that was per the parenting plan from 2018. Okay.
Right.
Correct.
If everybody agrees with that, then let's keep that as is.
Correct.
Presentation in 2 weeks is fine with me unless you want to do it on a Friday.
2 weeks.
Yeah, 2 weeks is fine.
All right, the 29th at 1 p.m.
Afternoon, Your Honor.
Thank you. Good afternoon. All right, we were here. Sorry, my computer, of course, is slowing down as the day progresses. We were here on the 25th of July. Mr. Gross was here present with Mr. Lynch. Ms. Lynch filed some orders regarding secondary support. A continuance was requested for a response. I have not received a response.
Well, Your Honor, the modified petition didn't really require any further response. We set forth our position, but we had just received that 50-page document, basically, at the time of the last hearing, so we needed time to go through it and see what she was alleging, what she was claiming, et cetera. So, but our initial response speaks volumes, and Miss King, or I don't know how to pronounce that last name.
Katori Singh.
I beg your pardon?
It's Katori Singh. Thank you.
Katori Singh modified her petition in some ways that are noted and appreciated, withdrew the request for dependent child support. That's certainly appreciated. So I think our initial response is sufficient, Your Honor, and we're ready to go forward.
So we're agreeing now that we're only talking about the one child that's actually going into college, not the one that's going into high school.
I think the post-secondary support would just cover both of them. Like, or do I have to petition later for the second one? Isn't it just kind of across the board?
Well, I mean, generally courts reserve on post-secondary support. There has to be, you're not going to get support for a kid that doesn't go to college. And because you ask 4 years before they are even able to go to college that they're going to go to college and want money, there's certain showings that need to be found where they're going. There has to be a sharing of information about where they're going, the monetary implications of that, their grades. So, I mean,
Yeah, no problem.
It would be pretty impossible to do that for a freshman in high school.
Sure. I just assumed that post-secondary, if they went to college, it would just happen that way. That's totally fine. I can file again for the other one.
Okay. So since it's your motion, ma'am, if anything that you want to, any argument you want to make, or if you want to outline what you're specifically requesting at this point.
I think I was pretty clear that the dollar amount I just thought should be simplistic and kind of, because in Oregon, they normally just extend the child support order, apparently, is what I'm told. I'm not a lawyer, so I'm not entirely certain on all those pieces, but I've had friends who that's what happened for them, and that seemed to be the standard here. And so originally we had intended to pay for the child's, post-secondary support, but if I figured that amount would be good and it would be easy enough so that way she could cover her expenses and do her studies. And then I think I asked for the child support. I changed it so that the child support for the other child was more in line with what Mr. Gross and Mr. Lynch were asking for one. I listed it as one child because that's how they did it. Only I adjusted the numbers to be more in line with what was accurate. And I explained in detail the difference of why I did that. The numbers that they provided versus the numbers that I provided.
When did you file? It looks like your last amended petition was the 24th of July. So that's the most recent information you filed, correct?
Yes.
Along with a new financial declaration.
Correct.
Okay.
And then also I showed for Joe's and for mine where it should land. For the support worksheet, I guess is what I'm talking about. Where the information they had provided, it looked like they were trying to write off the current, or to take out the current support that was being paid as maintenance, but I don't think you could put the support, at least from the way that I read the support, the document, the support worksheets. That's what I guess I'm just asking about that. So the support worksheets, the schedule, if they agree to what I put, that's great. I just took that out because it looked like they were trying to take out the current amount paid for child support in the income column, which wouldn't be the case if you're reevaluating what should be paid for child support. I don't receive maintenance.
Okay. So, hold on a second.
Among a few other things, but it's all outlined there in mine. So I haven't heard back from them, so I don't know if there's anything that they agree to or disagree to, or if they just, do you want to do theirs? I don't know where anybody's at. I've called and requested as well as emailed to find out if there was something else. I'm really trying to be, do this amicably.
Okay. All right. Mr. Gross, any response?
Well, Your Honor, in these 50 pages, there's some things that substitute for a sworn declaration, but it's stops and starts. It's 2 pages here, and then 20 pages later, there's another page and a half or something like that. So I didn't see any reduced request or simplified request for the 14-year-old. I do understand her request for post-secondary education support, and also she's asking for the court to modify the health insurance, and to that one we absolutely object. He's already ordered to pay his proportional share of any uninsured medical expenses, which does not include, whatever they want to call treatment. It's for medical expenses. And he has no problem certainly carrying them on his insurance until they age out of that obligation, or until they're able to find their own. So that really shouldn't be part of this equation, because it's already part of the child support order. On the post-secondary report, thank you for taking care of the 14-year-old ahead of time. We're only asking the court we don't really have a budget from Oregon Coast Community. We have a proposal that the parents provide support proportionally that adds up to $1,500 a month to the child. We're proposing that in lieu of, since we don't have an actual budget of what it's going to cost for Raya to attend that community college, that the court order what I typically see and what the courts typically order, which is that each party bear a third of the cost. And then any scholarships or grants or whatever that Raya may achieve or obtain will be credited to her third, or I've also seen it credited to the grand total and then reduced from everybody. But either one of those options, Your Honor, is perfectly appropriate. But my client doesn't have a problem providing for the kid's college. Just want it done reasonably, and want it done in a way that he's not carrying all the load himself. She is an adult now.
So I just wanted to say about that particular piece, I was looking at the expenses all over, and her personal expenses, for transportation and for rent or wherever, food, all that stuff is going to be the same, which is why I was saying 1,500 and then she puts it towards whatever piece she wants, because she may get scholarships. And as a matter of fact, this year, I believe she does have a scholarship I know she got $1,000 towards from Burger King for a scholarship to use there. But her personal expenses, like the being able to get there and the books and all of those things, are going to be pretty standard. And she's going to have that whether she's going to community college or whether she's going to a 4-year school. And like I said, here in Oregon, they just usually they just continue the child support, and then the child uses that towards it. So I thought that would be the simplest, because we've had considerable difficulty going back and forth and getting reimbursements. And so if she ends up having to pay, or I end up having to pay, it just seems difficult. And I totally am willing to pay. He's not taking more than his fair share in that 1,500. And if we want to pick a different amount, whatever, but that 1,500, that was kind of the standard at the colleges. Joe had suggested that she didn't need to go to Ivy League school, that she could go to a 4-year school. And so I just took what their standard is, and that didn't seem above normal from anything else for her to be able to exist while she's going to school. And so that's just what I was trying to do, because since she wants to try to go a medical track, she's going to be doing a lot more work. And if we were able to provide those expenses, she could take on more schooling or more education, because it takes a long time to do that. So she'll be in, it would be nice if she could get it done sooner than later. So the more hours that she could take, that was her plan. So, and I'm willing to pay my percentage. I put that in there. I'm willing to pay my percentage. I'm more than happy to support her. Just at our percentage level for that full dollar, for that dollar amount. I'm not asking him to take on all of it or more of it than is necessary at all.
May I reply briefly, Your Honor?
Yes.
Thank you very much. But she's asking for a court order of support, but we don't really know what the court is ordering. There's no budget for us. So just assigning a random number based on mom's assumptions for costs and expenses doesn't seem reasonable. If instead we get a budget from the school, we're talking about room, board, tuition, books, food, then, if it's divided up as we proposed, then that's reasonable, as long as she's not, well, we can argue about which school she may or may not attend later when she's done with the community college track. But I think that dividing it that way, Your Honor, is making sure that she's cared for, yet take some responsibility for her own education now that she's age of majority.
The amount that I provided was provided by the schools, and that's pretty standard for everywhere across the board. That would be standard. That for personal expense, I put that in there. It wasn't from the community college. The community college doesn't provide private, doesn't provide, because it's a community college. They're not showing personal expenses or those sorts of things. And she's on a track to get over to the other school quite quickly. So, I mean, at least we hope so. You can see her
What does that
grade.
even mean, though? What does quite quickly mean?
Hopefully she'll finish her community college this year.
So just 1 year of community college.
Maybe it depends on how long she's got an advising appointment. So she'll have to see how much longer, all the parts and pieces, but she was taking classes during high school. So she was dual enrolled. So she's just trying to finish that.
Okay. Can you point out to me in the 49 pages or that you filed on the 24th or in the information you filed previously where it outlines what OCCC's costs are?
I didn't put the OCC in there for their.
Isn't that where she's enrolled to start?
That is where she's enrolled right now. And I believe that her costs are covered by, they'll be completely covered by a grant. Hopefully we've got our fingers crossed. We're hearing back from someplace right now, from the office. She has another appointment with them. So what I literally am concerned about is just her being able to have her expenses, like her books, etc., and her living expenses managed right now. And it'll be the same when she goes over to another college like OSU, or if she is able to get into Johns Hopkins, any other of those, because all of those pieces are much more expensive over there. I'm literally just asking, and Raya's just asking for help with those other expenses, and the rest of it she will manage. She's willing to take out loans and do those sorts of things. Like I said, here in Oregon, they just extend and that goes towards their living expenses, and the kids help get their other parts covered. Where is she going to live when she attends OCCC? She will probably live here, or she has talked to a roommate, but she can't make that decision unless she knows if she's going to be able to cover it. Okay. And again, I'm willing to provide my percentage.
Mr. Gross, any response?
I don't know what to respond to, Your Honor. This is a vague request at best. There's no actual budget presented. Mom has decided on a random number for everyone to pitch in. So
it wasn't random.
if the court,
can you not interrupt people?
Yes, sorry.
I would appreciate that. Sorry, Mr. Gross, go ahead.
Thank you, Your Honor. So assuming that she's meeting all the criteria, which we have no doubt she's going to succeed, continue to be enrolled, continue to do well, and progress toward her degree, and we receive information about expenses for those things, then if we divide it up by the percentage proposed, then we make sure that everyone's taking responsibility for this, including both parents and the child, as is appropriate, Your Honor. So other than doing it that way, just assigning some random expense for the parents to pitch in, I don't have any idea if that's going to be too much, if it's going to be too little. There's no way to predict this.
I have to say I'm a little bit stymied by the request when we're supposed to go off general numbers of what everybody's standard numbers are, but we don't have any numbers from the college that she's actually attending, but we're pretty sure that they're covered by grants, but we're not really sure, and we don't know where that she's going to live. So I'm a little concerned. It sounds like Mr. Lynch is willing to provide support for his child as she moves on into college. Great. I don't know that I'm in a position, even with the plethora of pages worth of stuff that's been filed, to know what to order or how to order this. Frankly, I'm a little bit, I'm considering that, I feel like this is probably something that the parties could agree to without having to come to court, especially once we get the actual numbers, because it doesn't sound like anyone isn't willing to pay their fair share towards this expense. So I would encourage the parties to do that. I'm not going to me, a third for each makes perfect sense. And if she's getting a grant, that would probably take care of her third, and it would just be mom and dad splitting the remainder proportionally. That seems a reasonable way to do that, but I don't have sufficient information that's been provided by Ms. Singh to be able to dictate what those numbers are.
May I? Oh, sorry.
You can say something else, but it's not going to show me where in here are the correct numbers are.
Right. So may I ask what those things would be covering? Will that be covering, because she needs car insurance. She has to be able to travel back and forth. It's not like community college doesn't have a campus for her to live on. So she needs those. Will those pieces, those are the questions, if we're going to, that would be part of the piece. Like that needs to be covered. Her books need to be covered. Her living expenses need to be covered. That's why I put the living expenses, and that's why I use the standard, because when Joe told me, he said from a state school, that's what I put. And originally in the state school, that's what I pulled out. There is a page, I have to find it here, that from both Oregon State University and the University of Oregon, I think was the other one I put, that in the original filing that shows their standard for school expenses for their tuition, and then it breaks it down to their personal expenses. I mean, I could simply provide that, but we're talking like rent around here is like $1,000 to $1,200 to $1,400, just depends on what the rent is for each, for if she wants to do that. I don't mind her living at home, but she's certainly going to have other expenses. Again, the travel expenses, she's going to have food expenses, she's going to have book expenses, extracurricular expenses, such as they were previously in the child support order. So if we just want to go with the same of what the child support order was and extend it, which is what I originally asked, was just to pay for 2, like they do in Oregon, just to set it for 2.
Okay, I appreciate that information, but I'm not going to base an order off of a standard that occurs in Washington isn't Oregon. I'm a big fan of Oregon, but Washington isn't Oregon. RCW 2619-090 outlines some of the things that the court has to consider when ordering a specific post-secondary support amount. And additionally, there's attorneys that volunteer and are at the courthouse Mondays here in Cowlitz County, Mondays from noon to 2.
I live in Oregon and they won't work with me because I'm an Oregonian.
Well, that's too bad. I did not know that was something that they were turning people away for. So I will look into that.
That's what I was told when I called.
Can you just stop interrupting me? Please?
I'm so sorry.
Okay. Second, so I'm going to ask you to just try to work with Mr. Gross and Mr. Lynch on the post-secondary support. And if there's some better numbers and you need to come back to court, great. There's also a motion for an adjustment in child support for the child that is now entering high school, so is still under the age of 18. Any comments on that from either party?
I just asked that my numbers be the ones that are approved. And then also actually the health part, I literally just wanted that put in the order because that is how we've been handling it. Mr. Lynch agreed quite some time back, actually when we first got divorced, that I cover the kids' health coach expenses, which they've gone to this health coach since they were born. And so I cover that and the phone for them to be able to communicate back and forth with him. And I do that 100%. And then he covered 100% of the healthcare expenses that were medical or, all those things that were standard covered by his insurance. That's just how we've been doing it. I wasn't asking to do something different than we've done.
And was that you're doing that because that's what the order dictated you do, or are you doing something different than the order that's the final order that's been entered?
Right. We were doing something different than the final order was entered. And since we had agreed to do that off record, because we had agreed to do that originally, but that didn't get put into the record, right? And so we had a gentleman, my ex-husband said we had a gentleman's agreement on that. And that's one of the pieces that I actually put in the email or in the text where he said, yeah, I remember that. And he had been paying those pieces, but he hasn't had to pay very much because they don't go to a lot of medical things. It's only been their counseling and some chiropractic that hasn't been covered. Most everything else has been covered at 100%.
Okay. So you cover insurance currently?
Joe does, because I don't have access to insurance. I'm a substitute teacher and I don't have insurance. I have Oregon Health Fund, which I did just get the kids covered under the Oregon Health Fund. So again, he won't have much out of pocket, if any.
Okay.
But I'm just saying that was what we did before at the 100%. So he was paying for, because they've been going to counseling for quite some time. And I just was wondering if I was hoping that the healthcare would be extended, and I know he's done that, but if we just did it the same way we did in the order until she graduates, I guess.
Okay. And then your, the current support amount was $982.13 approximately for each child, total of $1964. That was back in 2021. Now we have one child that has turned 18 and the other, so you're asking for an increase in the, for the younger child. So your current request is $19,049.31 for the remaining child under 18.
I'm looking here to see where that was. I think the amount. Your question was, the total amount?
What you're asking for him in support for the youngest child.
Sorry, I can't see my screen of basic child support obligation. I think on the one that I put in, if I'm looking at the right page, was $15.56, and that we each pay our percentage. So the basic child support obligation from him would be $1291.95. This was on my modified part because after I got his finances, then I did the math the same way I did the math for myself.
I, for the life of me, cannot find that number on anything that's been filed, but Mr. Gross, any response to the motion to adjust child support for the youngest child?
Yes, Your Honor, thank you. He's already paying about 84% of the expenses at the 983 roughly level. We do think that mother is voluntarily underemployed. She chose to move to this depressed area, and with a bachelor's degree, it's certainly our opinion that over the last 2 years she could have found a better job than this part-time substitute teacher gig. I think that the support as it is perfectly sufficient for the 14-year-old. I don't think the appropriate showing has been made for any adjustment to that, especially when mother is making basically at or below minimum wage.
May I interrupt?
I mean, the Washington State guidelines would indicate that without special circumstances, we will start applying the Census Bureau median net income. And for someone of Ms. Katori Singh's age, I'm not sure exactly how old she is, but it's either $4,008 or $4,067 as the standard. So unless she can show us somehow that she's not voluntarily underemployed, I don't think there's any basis to modify this.
All right. Ms. Singh, you can reply now.
I'm not underemployed. I was a homemaker before I came out here. I've had to move here because this is where my parents lived, and Joe insisted we sell the house, so I didn't have anywhere else to go. I did not, and it is a depressed area, but I do very well. I make more than minimum wage. If you hammer out the amount of money I make per month, it's in my child support worksheets that I put in, and also my financial declaration that I put in. The support worksheet I put in was on July 21st, 2023. And I'm doing the best that I can here. I have applied for lots of other jobs around here, and I have yet to be hired. I really only have teaching. I'm a substitute teacher now. And when I was married, I taught the kids at home. I homeschooled the kids. And so I'm not sure what else you would ask me to do. I don't have a teaching certification. I would have to go back to school to get that. And that would, I don't have the money to do that. I have applied at the school for several different positions to help. So if I get a position, I will be delighted, and I'm more than happy to pay my percent, but I am not underemployed for this area. And I don't understand how you think I would be. I'm making more than minimum wage. My gross monthly income, wages and salaries that I listed here is $2,139.58. Joe's is $12,684. And even in the way I redid it, like I redid it, and he would be down to 83%, and I'm at 16.97, using the same numbers in the way that we calculated it previously. Not asking for more than my fair share or more than Lucy's fair share. I just think that you guys actually were the ones that put in the child support originally. and adjusted the price on it. So I thought that's what she wanted to do. That's why I did that. I put all that paperwork together.
Your Honor, she received over $300,000 from the entire proceeds from the house sale. So there was plenty of opportunity to get re-educated, recertified, whatever she needed to do to get a better, more appropriate job. She chose not to do that. I don't know what happened to the money, but it's set at a perfectly acceptable level, you know, and it's already quite a burden on Mr. Lynch. Well, not a burden. He's happy to take care of his kids, but it's already a financial cost to him that's significant enough. And we can only expect that to increase now that Rye is entering college. I think it's inappropriate to also bump up his obligation for Utona based on this lack of showing.
May I respond to that?
Briefly?
I got a house so that we would have somewhere to live. We didn't have anywhere to live. It is very difficult to get housing and accommodations here. So we have what we could afford, which is this really cute little tiny old house, but it's got lots of fixing things that have to be done to it. But we had to have a place to live. And that's where the money went. I couldn't afford to do both.
Okay. I'm looking, so, and I guess it's within your right to request a modification of child support. It's 2 years have passed, that there's nothing wrong with that. What I am looking at is I'm looking at the proposed child support worksheet that was presented by the petitioner in this case. And I'm looking at the child support worksheet that was entered in April 2021 on final disposition of this matter. And interestingly, the income of the petitioner increased from 1840 to 2139. So not super significant. And in the for the respondents, income was listed at 11,775 and is currently listed at 12,684. So a few $100s each party has increased in the last couple of years as far as income goes. Obviously, other things probably have increased as well. In looking at the proposed order, and I do have here, just give me 1 second because I have the numbers that, so I have from this year, and these numbers vary, but a similar case, imputed full-time minimum wage, which is normally what happens when is above the amount that is listed for the petitioner in this case. So, and I know Mr. Gross kind of alluded to that fact. I have, so I have some concerns here with the incomes that are listed and whether there's really been any kind of significant change that would support a modification of child support.
May I say that the difference was that now we're down to one child instead of two, and that's just the line that was on the support order. And if it should be at the one, that's fine. Or excuse me, at the two, that's fine too. If post-secondary support is going to be allowed.
I'm not sure I understand what you're saying with,
yeah.
So if you want to restate that, I don't, because I'm not following what you're saying.
So the number that was proposed for the child support was taken from the Washington list there of child, where it shows the numbers that, what's the worksheet, right? It's taken from the worksheet and for one child instead of for two. Whereas previously it was set for two, and this one just moves it to the one, which is what I thought they wanted, because when they put their proposed child support worksheet, they only put down for one. So I assumed that was different than post-secondary support. Since I'm not a lawyer, I wasn't sure of that. But if it needs to be on the line for two and do half that, I guess that makes sense as well. But only if post-secondary support is going to be offered, because otherwise we're only supporting one. And my as far as minimum wage, the minimum wage in this area may be different than the minimum wage where you're at. I don't know. But I do know that I'm making more than minimum wage for the area that I live.
But you're only working part-time.
I work as full time as I possibly can. It's substituting is when there's not a list. So like I worked full time for a couple of months because I was able to get a position where somebody had gone out on leave. So sometimes
I'm not worried about that part. I just,
Yeah.
you're okay.
But I also have another job where I sell water filters. So I am spending that many, I mean, I'm working full time. If you put the two together.
And that's included in your income that you've listed?
Yes, it is.
Okay. Mr. Gross, any further response?
Well, yeah, we're down to one child, but there still needs to be the substantial change in circumstances and income in this case for the court to modify the order. And obviously, I agree with the court that we're dealing with a couple $100 here and a couple $100 there, which is going to move the needle probably what, $10 or $20 on a modified order. It just doesn't seem like that's an appropriate resolution, considering that the court hasn't denied the motion for post-secondary support, left it up to us to try to coordinate that. And if we cannot, with an appropriate budget and more information, the court can then order it. But that's still something that's coming down the tracks. So it just doesn't seem like there's enough grounds to modify that order, Your Honor.
Well, and that I think that's where I'm at. I'm not, so to capture everything, I'm not denying post-secondary support. I think it sounds like the parties are in agreement on that, but we don't know the numbers to be able to work out what it's going to be. I'm encouraging the parties to try to reach an agreement together, or at least come up with some actual numbers for where she's actually attending school and what the cost of things would actually be for that specific school and the classes that she's taking. Then we can go from there. Hopefully that can be agreed. So I'm not denying that. I'm just, and I'm happy to set a review date if that helps the parties kind of sort this out. So that's as to the post-secondary support for the eldest child. As to the youngest child and the request to modify the child support order, I don't have enough information here to substantiate that there's a significant change. Frankly, Mr. Lynch's support numbers may increase depending on what's going on with this post-secondary support. And that's something that the court could and may take into consideration if she starts attending, for lack of a better word, fancier colleges, depending on what track she's on. So I think the current amount of $982.13 for the youngest child will remain.
Okay.
And I guess since it's your motion, ma'am, do you want me to set a review date to come back on post-secondary support? And then that can be struck if there's an agreement reached between you and Mr. Lynch?
Yeah, then yes, that would be fine. My question is though, what needs, will it need to be reviewed again when she goes to a 4-year school? That's what I was just trying to avoid, was us ending up being in court all the time, which is fine if that's the way we do it.
Potentially, unless that's something that you're able to contemplate in an agreement with Mr. Lynch and his counsel.
Okay, so what does this support, what would it include? So what numbers do you need for a budget? Is it going to be housing? Is it going to be insurance? Is it going to be all the parts and pieces that the standard of what OSU, et cetera, said, or is it going to be different?
Well, I need it to be from a college that she's actually attending.
Gotcha.
And what the expenses are for her to be able to do that. So that's...
Okay. So whatever tuition, living expenses, et cetera, for the area. What if the college doesn't list tuition or living expenses for the area?
Well, they have to have expenses for dorms. I mean, there's
no dorms at this community college.
Okay. Then I ask you to look at the statute that I already referred to.
Okay.
I can't walk you through the whole process. I can't give you advice from the bench. My hope would be that since Mr. Lynch is in agreement to support her through college, that this shouldn't be too difficult, but we need actual numbers, not just generalized numbers.
No problem. I can do that. I just thought this would be the easier, simpler way. In fact, I thought it would be less money for him. So
thank you, Your Honor.
I'll be happy to do that.
All right. I'll set a review for you on the 5th of September at 1 p.m. That can be struck if there's an agreement.
Okay.
Very well.
What about
Thank
the
you,
health
Honor.
piece?
What about the what?
The health piece.
Mr. Gross, I forgot what your response was to continued health care for child in college.
Well, Mr. Lynch he's already committed to providing health insurance coverage. The problem with the mother's request is she's asking for him to cover that 100% and cover 100% of any uninsured medical expenses, et cetera. And that's just way out of line. And, his proportional share is already 84% of everything. So, they may not seek many different kinds of treatment. If they go to counseling enough that it's already costing him $600 a month or so. So there's absolutely no basis for increasing that to 100%. So he's going to keep providing insurance for his children until they're, I think the age is 26 is when they age out, unless they can get to a place where they can obtain it on their own.
Okay. May I ask a question then?
Yep.
So the other pieces that we've been covering, that I have been covering at 100%, could they be rolled into that so that it's percentage wise, the that we had agreed on earlier, which I have been paying 100% of, which is the healthcare of the coach, as well as the health coach that they've been seeing since they were young, because I cover all of that and the supplements that are ordered from that, which is equivalent basically to what he's been covering for the other part, which is why I just thought it would go in there.
I'm not exactly sure what you're talking about, Your Honor, but proportional share, he's providing insurance. I don't think there's anything further to talk about. I don't understand what else the court could possibly order at this point. And if we have a disagreement about what's going to be covered and to what percentage, then that can either be discussed between the parties and worked out, or if it's in violation of the court order, be brought in here on contempt. But we got to be done at some point.
I think the proportional share, so the order that we're operating under, because it's still in play, is from April 12th, 2021, and it's proportional share of any uninsured medical expenses. And it specifically says that this does not include costs of children's life coach. I don't even know what a life coach does or what. So that I'm going to leave that where it's at.
Okay.
All right.
May I ask clarification then?
Thank you, Your Honor.
If September 5th at 1 p.m. is the review. So
so if you don't reach an agreement, then that'll be your date. So you don't have to note it back up. That'll be your date to present hopefully some more solid evidence on numbers for the school she's attending.
Okay. And then do we review it every time she switches schools?
If you note it up for it to be reviewed, I suppose we can.
Okay.
Mr. Zandy.
Right, thank you.
Mattson
All right,
and
good luck.
Maza.
Thank you.
Francis and Francis is mine, Judge, and it will be so much
sure.
quicker than that last one.
Sorry. Sure. Francis and Francis, 2330027508.
And this is Ms. Francis's motion. I represent the respondent, Eric Francis. I think the pleadings are what they are, but obviously let Ms. Francis address that as she sees fit.
All right, Ms. Francis, go ahead.
I put a restraining order on him to get him out of the house. My husband's an alcoholic. He needs to seek some treatment for that, but when he's not drinking, he's a very decent person. It's the alcohol. So I don't know where to put this at. I don't want him at the house, but I want to have contact with him because I do want to eventually get him to see his kids because, you know, they're his kids. So I served him with a motion of divorce or whatever you want, whatever it is. And he started treating me way more aggressively and it was getting really bad. So I wasn't going to do a restraining order until it just got worse and worse and worse. And he just drank so much. And I had to get away from that. I couldn't have that with me and the kids. So I don't know where to put it now. Now I'm just kind of at a loss. I want contact with him, but I don't want him at the house. I don't know how that works or if that's even a thing to work. So that's kind of where I've been at right now. It's just the drinking. It's the drinking. That's
all right. And when was the restraining order filed? Or was it the temporary restraining order in the family law case? Or did you file a civil order?
I don't remember the date here since I filed
July 12th, Judge, and it's filed under the same cause number as the divorce.
Okay.
And it wasn't served till like almost 3 weeks later. That one was really tricky. I didn't know what to do on that either because I called to have him served because another weekend was coming and he starts drinking at 10 a.m. and I can't, with the more drinking, the more aggressive. And I couldn't do that all night long with me and the kids. And it just, I couldn't do it. But like I said, if Eric gets treatment, like he is the most decent human being in the world when he's sober, but it's been 17 years of him not wanting any of that. And he's an addict. He's been an addict since he was 19. And he got rid of one of the addicts for the alcohol, if that makes sense. Like he was addicted to something else for another something else. So now he smokes weed and he drinks alcohol. That's what he does all the time. And I'm just at a point where I need him to admit to it own up and just take care of it, and then we can move forward, because I have no problems with him besides the alcohol. We get along fine otherwise. If it's just the drinking. And he gets very mean, and he says some very, very awful things. And trying to escape that in a house that's this small is really hard for me and the kids. So that this is where I just end up shaking all night long, and I can't sleep. And I need an escape, and I can't. That's why I sent the restraining order, because he cannot be constantly doing that to me. That was too much for me. And 17 years of that is just too much. So I don't know where to put all that right now.
Okay, so what I do see in the restraining order, that's temporary restraining order that's entered, it does not, and I guess Mr. Zandy, correct me if you see something different, but it doesn't prohibit conversations, like our communication between the two of you. I don't see that as part of the
I didn't want to put, I didn't want to put that, but I don't know what they changed, because I said they changed it. So I felt like it was.
I have a suggestion for all of this that I think will work for everybody. And that's just simply an outside the box restraining order that says nobody harasses or annoys the other. They leave each other alone. It doesn't have the criminal implications on that. And frankly, given the information provided today and kind of the vagueness of the initial request, which was about 2.5 weeks or so after the initial divorce petition was filed, an outside of the box order that everybody plays nice and acts like adults is probably appropriate. I think that also is probably reasonable if the court, I didn't hear any objection to this in any of the pleadings, adopts my client's proposal, which is essentially list the home for sale as the parties have been contemplating for a while. That would allow him to get in there, make improvements, repairs, clean out the dog feces and urine and garbage.
Don't interrupt, please.
Okay.
I've had a long day, and people need to be polite to each other, as frustrating as this is. So please do not interrupt. You'll have a chance to speak.
Okay.
Go ahead, Mr. Zandy.
That's littered throughout. That's pretty much the only source of equity these people have. And again, this is a 15-year marriage in which my client tells you the house is one concern, and the number one concern is his time with the kids. So the restraining order, again, 2.5 weeks after the date of filing for the initial divorce petition, surprised him. He was at home cooking dinner, again, for the family. Sheriff shows up, gives him that, and he's essentially out and planning different things and living his life now at a friend's home based on that gratuity of that said individual. So what we'd like to see happen is some kind of an order related to the house, also some order related to his time with the kids. It's always concerning to me as a practitioner when we get these protection orders that are granted based on somewhat vague allegations. And I certainly think this would qualify, in which the allegation alone basically forces my client not only out of the house, but also away from the kids because he can't readily communicate under the basic pretense of those orders. He would like to have time with the kids. He's always been bonded with the kids. The kids have loved dad. Dad loves the children. And again, I think that's been pretty much how things have been over the course of these kids' lives. They miss dad. Dad misses them. And there needs to be some communication and some contact. What my client's proposing for the parenting plan and visitation, again, I don't find that to be unreasonable given the circumstances, is that he sees both kids. Trent's 15, Elena is 7, every weekend. That's both Saturday and Sunday for several hours. They don't need to have overnights. My client isn't pushing that, given the fact that he's living with a friend and there is limited space. Everybody acknowledges that currently. But getting dad back in their lives certainly seems like the appropriate thing to do. I didn't see anything in any of the information outside of, well, he's bigger than me and he's a bully and says things I don't like, necessarily giving rise to any kind of restraints on those kids. He tells you he's more than happy to get an alcohol evaluation if that's what the court wants him to do. He does ask for a mental health evaluation from Ms. Francis. And again, we provided you with some documentation showing his concerns. Elena is 7 years old, being homeschooled, and we have significant fear that she's not doing well whatsoever. We put that in our response, and we get no information on the reply from Ms. Francis, who's homeschooling the child. The photo documents that we provided you, again, his information is concerning. My client details for you that Ms. Francis spends an exceptional amount of time playing video games, to the point of his concern that she's addicted. He tells you he comes home from work, cleans the house, makes the meals, go to bed at 8 o'clock. She's playing video games, wakes up at 2:30 or 3 in the morning, and she's literally, as the one photo indicated, kind of hunched over with the whatever that device is on her head, asleep on the couch in the same position as when he left her several hours earlier. That's starting to bleed over to the care of the kids. Elena, you've seen the picture of her bedroom. It was filthy and disgusting, for lack of a better term. You see the condition of the home with the dogs, the condition of the kitchen, the bathroom, and the light. And that's a concern. We don't know how Elena is doing in school. Now, my client attempted to address this with Miss Francis prior to separating and was told in very uncertain terms, F off, you can't take pictures, Washington's a consent state. So there's issues on both sides. There's a history on both sides. But what we have is two kids who deserve both parents. They deserve to be well taken care of and safe and in an environment where they're going to thrive. And right now there's concerns on both sides, which I think does give grounds to appointment of a guardian ad litem. I think that certainly the allegations of both certainly supports that, and that's our position. As it relates to the finances, again, I'm not entirely certain what Miss Francis was asking for. We provided you the financial information we thought was appropriate. My client is a logger working for CNC Logging, makes $43 an hour. We provided you a pay stub for that, also filed under sealed his tax information from 2022 showing about $110,000 in gross earnings. And from that, he's been solely responsible. Now, Miss Francis, we believe, has a bachelor's degree or the equivalent. She just refuses to work and would rather, again, play video games. What we're suggesting is that my client pay the monthly mortgage of $1,043 per month. That should be offset by whatever family support the court would otherwise order. My client also acknowledges the fact that he's going to have to pay the Ford auto loan of $730 per month, the Visa of $175, the Walmart credit card of $107, Target credit card of $40, Care credit of $50, and the Amazon card of $150 a month. All adding up, just the community debts and liabilities is about $3,000. He acknowledges that. Now, he's essentially supporting his family, supporting his wife of 15 years while he's sleeping under the gratuities at a friend's home. That's our position as it relates to that. What we would like to see sooner rather than later is some kind of a court order that requires Elena either one, to be enrolled in public schools, depending on what the court's going to do with the home, or number two, get some kind of documentation from the homeschooling efforts of Miss Francis that shows that Elena is where she needs to be. Again, we're at somewhat of a crossroads with this. My client needs some assurance that the child's educational needs are being met, that we have very little information or evidence related to that. And again, those types of conversations, his concerns about the house are what led to her going down and filing for the protection order. That's where we stand. The court wants to get an interim GAL review on board and get a preliminary investigation. That's probably appropriate as well, given the circumstances. And we understand that, you know, the house and the repair it's in right now is of very significant concern, and the impact on both kids, most importantly, Elena, who's being homeschooled in that environment. We've got a lot of question marks in this case. I think the alcohol evaluation for my client would be beneficial for the GAL. I think some kind of mental health evaluation for mom would be beneficial for the GAL. And seeing where we're at with the condition of the home, as well as what's going on with the homeschooling, I think is of paramount importance at this stage of a lot of uncertainty. That's kind of where we're at. That's my client's position. We're asking you to, again, grant the outside the box restraining order, which probably makes sense given what Mrs. is indicating. Also asking for some kind of order related to this house. If that's to be listed for sale, we've given 3 realtors. And we ask that the parties cooperate with that person, and any issues related to the material sale of that, showings, price points, contracts, repairs and maintenance, etc., be determined by the realtor.
Right.
Can I respond to that?
Very briefly.
Okay, I have a lawyer and she wasn't able to make it today. So I feel like this needs to be seen by a lawyer because, first of all, that stuff is his hearsay. He's trying to grip straws right now, anything he can to hold face for being an alcoholic and abusing me. And
But ma'am, let me just say this. You saying he's an alcoholic is also hearsay then, if we play by those rules.
He's got 2 DUIs.
I don't have that in front of me.
His work.
So that's,
I'm just saying, that's why I need my lawyer here. She'll be able to prove all that to you. He's also had it.
Who is your attorney going to be?
Okay, her name is Karen Jones from Pacific Cascade Legal. And I just paid her today. I just couldn't have her here today. Obviously, Eric has been saying what he wants to say, but I'm going to tell you right now, I explained all that stuff, and I did not serve him because he was taking pictures. I served him because he is aggressive. And I could say a lot more. I just didn't want to add that to the case because I wasn't trying to go there. And so I'm trying to hold my tongue now, and I'm shaking because I'm a little scared. But for one, this is not what's going on. I have a sister who works at the rehab center. She's seen all this stuff. I have all my family around.
Okay. Ma'am, I don't need any of that information right now. And I understand this is over.
And I have.
Okay, I'm talking now. Oh. I don't need that information right now. That's not going to help do what we need to get done today.
I need my lawyer.
I understand that. So, and I appreciate that you've gotten one. I don't know how quickly Ms. Jones is able to be present. So what I'll do is, I'm going to do a few things today because I think it's important to do a few things today. And then we'll set this for a review, and hopefully Ms. Jones can be present to represent you while we finalize the rest of it. I do think a GAL is important, given the circumstances.
That's fine.
So I'm going to ask that be something that we deal with when Ms. Jones is here. I'm going to set this to the 29th, so 2 weeks from today, to discuss a GAL, any support orders.
Also, can I mention?
Can I
that-
keep talking and not be interrupted?
Oh, I thought you were.
Because that'd be
done.
really great if I could.
I thought you
All
were.
right.
done.
So discuss a GAL, to go over any support requests and orders. In the meantime, I'm going to say that, Mr. Francis will pay the bills and the mortgage. So, that keeps happening. I'm not going to order any support at this time because I'm sure, Ms. Francis would like her attorney to be able to weigh in on that.
Yeah.
I am going to order, it sounds like Mr. Francis is willing to do a substance abuse evaluation. I'm going to ask that he get started on that, and there can be collateral input from Ms. Francis. That means that you'll get notified where he's getting his evaluation. There'll be a release signed so you can discuss your concerns with that evaluator as part of that evaluation. We'll discuss the mental health evaluation request in 2 weeks when hopefully Ms. Francis' attorney is present. I'm going to order that neither party give any disparaging comments to anyone and to the children about other parties. Dad, stay away from the home at this point. There's nothing that doesn't allow text communication if the parties are comfortable with just text communication at this point. I am going to allow visitation to start and just kind of as an interim get along. Dad's going to get I'm going to give him 8 hours on the weekend. And that'll be every weekend until each weekend until our next review. Dad's not to drink 8 hours prior to or during any visits with the children.
Did you receive my photos?
Where the house is cleaned up?
No, and where his alcohol was down there all over in his truck and also, can I mention that when he was taking photos of me sleeping, I had to pretend like I was sleeping because if I'm awake while he's awake, I get screamed at all morning. And he screams at me and he sings at the top of his lungs and he's like, "Ah, Dio," and he just does this stuff to get under my
Well,
skin.
again, Judge, I'd object to anything that's not in the pleading.
That's fine. But I just need my lawyer because a lot of that stuff he does is normal everyday house cleaning. You can see that my toilet is completely clean in that picture, as if my house is so messy. Then why is that toilet just spotless?
And I'm not worried about that. I'm not going to order the sale of the house at this point. Your attorneys will hopefully be here in 2 weeks. We can raise the issue of the requests of the respondent to sell the house. So we can raise that again when your attorney is present. The mental health evaluation, the GAL, any support orders. There was one other thing that I wanted to.
If we could use video footage, I have some too.
I'm not concerned with that at this point.
Right.
Yeah, this is a new case. There's a lot of accusations being thrown about.
But the kids can witness to everything.
Okay, the kids should not be engaged in any conversations about the dissolution, the requests of either party for visitation, the house, selling that, anything that has to do with this case should not be discussed with the kids, period.
And I don't do that.
Exchange is at the Hall of Justice, Your Honor.
That seems appropriate.
And should we call it Saturdays at 10 to Saturday at 6?
That work for you, Ms. Francis?
Yeah. Also, I don't know. Yeah, that would be fine.
Oh, and then the other reserved is the homeschool. Sorry, I didn't want to lose track of that, and that's something I'm assuming Ms. Francis wants to. Can you please stop talking over me? We're trying to make a record, first and foremost. Second off, I'm talking and you talk. Okay. Sorry.
I'm just nervous.
I understand that, and I'm trying to be patient, but it complicates things because the record isn't going to be clear. So the last thing that I want to remember to deal with in 2 weeks is the homeschooling request regarding. I'm sorry, it was Elena. So just for the record, making that list. Saturdays 10 to 6 exchanges at the Hall of Justice are appropriate. And we'll set the remainder of these issues to the 29th of August, 2023, 1:00 p.m. I'm assuming, Ms. Francis, that your attorney will be filing a notice of appearance. If there's some concern that she's not able to appear on that date, then she'll need to contact Mr. Zandy and work out if there's an agreed different time for that to be set. So she'll need to contact Mr. Zandy. Okay.
How do I get the information to give her?
What information are you referring to?
Said that she needs to be like responding and be there. And I just don't know when you want that, where that is. You've been saying stuff, but like, this is overwhelming for me as it is. And I'm trying to jot it all down, but I'm still like, I don't know exactly what times and date. How do I get the dates in case I forget? Because I've got a lot going on. I just put my horse down yesterday and I'm going through the motions right now. So
Just have her contact me, ma'am. I'm happy to talk to her.
So I'm sorry to hear that. Your attorney can directly contact Mr. Zandy for any dates and orders. Excuse me. You can contact the clerk's office for any dates to get information about that. It's
Okay.
2 weeks from today, the 29th of August at 1 p.m.
Okay.
Your attorney should know how to file a notice of appearance and get that process started on your behalf. And then really the only thing that I ordered in the interim is for Mr. to get start a substance abuse evaluation that you can have input on, and that he continue to pay those bills that were listed, and that there's visitation with the children the next 2 Saturdays. So that's all I've decided on today. And then that there's no disparaging comments in front of the children about either party, and no conversation about this case with them. Okay.
I don't want to as much as possible.
It's a difficult process, and I understand that, and I appreciate your struggle. It's and I'm glad that you have an attorney coming on board to help you, and we'll see you in 2 weeks on the 29th at 1 p.m.
Thank you.
Your Honor, Amanda Holder here representing Ms. Maston.
All right, 16300547. I didn't see a response, and I didn't receive response. I don't know if you received anything, and I see their service.
I have not received anything, Your Honor. I did see that it appeared a phone number that my client confirmed was Mr. Mazza's phone was on the hearing at the very beginning, and I did see that, but he is no longer here.
All right. Well, what would you like to do?
Well, if you've read the pleadings, which I assume you have, Your Honor, he has not been following the parenting plan, and at this point in time, we would like to hold him in contempt due to his drinking when he was with his son, when he was not supposed to be doing that. We are further going to plan on modifying the parenting plan based on what has already been done. But in the meantime, we do want to hold him in contempt and have him pay for attorney's fees. I don't know if it is possible, Your Honor, to modify the parenting plan at this time without a motion in front of the court, but we would just like to make sure that he does not have custody of his son for the 4th of July going forward, as it appears he is not able to control himself when he is around his family and with alcohol present.
I did receive and review the motion in order to show cause. The concerns around July 4th are obviously substantial. We just entered a parenting plan not even 2 months ago.
Yes, Your Honor.
Final
That was
parenting plan.
June 26th of this year.
I am going to make a finding of contempt. I also, for the record, note that there was service of the contempt on Mr. Mazza on the 15th of July. That is in the file. You didn't have a proposed order, correct? No.
No, Your Honor, we did not.
All right. I will, hold on here. This computer, I'm so glad this is almost done, because my computer is just not being nice today. All right. I will make a finding of contempt, and I'll award $1,500 in attorney's fees for the motion, and I will sign that upon presentation. I think a modification to the parenting plan probably does need an actual motion and notice to Mr. Mazza. So I will let you note that up and see it when it happens.
Thank you, Your Honor. When would you like a presentation of this?
Well, you can send it to me whenever. We can note it on the docket, or you can just send it to me ex parte, either way.
I think ex parte would be appropriate, Your Honor.
That's fine. And then you can note up whatever other issues you have whenever you need to.
All right. Thank you, Your Honor.
All right. Thank you.